Good morning, everybody. Absolute pleasure to be here with you. Something a little different for your day today, a bit of a legal spin on some of the things that you may come across in your day-to-day practice. As Shane said, I'm a planning and environment lawyer, and so part of my role is to assist clients dealing with the legal requirements that apply not only in relation to utility infrastructure, but particularly around vegetation and native vegetation. And recently, that's taken me on more than one occasion into dealing with underground pipes, particularly water and gas, less so on the electricity side of the business, but I'm hoping to address you today on those three things. I guess before I wanted to get into the detail, I wanted to just share with you some high-level thoughts about this topic. The first is it's not you. It's very complex. And you do not need to be in any way scared, ashamed, confused that you don't necessarily understand this regime. It can trick up the most seasoned practitioners. There's a lot of law. There's a lot of law that overlays itself. And as a consequence, the regime is extensive. And if that's the one thing you take away today, it's the area it is tough. And it's okay to try and go back to your businesses and get in place some compliance documents, some checklists, and some compliance tools that can really help you on the ground navigate this stuff. The other thing that I wanted to say, and it's quite important conceptually, is that environmental law is criminal law. Now, that may seem a bit unusual to you, but that's the way it works. It's just like health and safety law. If you commit some sort of breach of the regulations or the Act in planning or environment matters, they are criminal offences. And so what that means, if you are unlikely to be caught and convicted for some non-compliance with the law, that can obviously have an impact on the criminal record of the business, and it may affect your ability to tender, particularly for government, local government work, contracts, that sort of thing. It can also carry high fines as well. So it's something that we all need to be aware of in the room in the course of our business. The other thing I think I just wanted to talk about in the context of liability is that often many of you may be working as sole traders or in small consultancies or as contractors to a principal contractor. The way that environmental law works is that it's not just you who's liable for this if you get it wrong as the guy who actually does the works to the tree. That liability also attracts to your principal contractor and potentially your client who's engaged you to do the work. That means that they should not be pushing this onto you. It is their liability as well. We have a joint and shared liability in this space, and it really means that everybody in the industry needs to be aware of regulation in order to get the job done well. So what I'm going to talk about now is what I think of as a bit of a puzzle. And for many clients, it's exactly that. Even the most, as I said, seasoned practitioners on the legal side and asset owners and utility owners often get caught up in some of the problematic natures of the regulatory puzzle. And what I wanted to talk to you through by way of overview was just some of the different laws that can and indeed do apply in different situations, because there's a lot. The first one is the Planning and Environment Act 1987. That's the main planning law for the state of Victoria. And it affects anything we want to do when we're doing development works. When we think of development works, often most people would think of things like constructing buildings, but lopping, removing, destroying vegetation, trees, native vegetation is caught up in that definition of development because we are doing something to the land. So the Planning and Environment Act is one of the key pieces of legislation that governs this area. One of the things that the Planning and Environment Act does is that it creates a planning scheme. And that is a document that applies to each piece of the state, each local government area has its own planning scheme, and through that planning scheme, the land has zoning controls which determine what you can and can't do in the zone, and it also has a particular legal control that can be applied to land which is called an overlay. And an overlay provision is the key thing that you in the room need to be aware of, because an overlay provision is what stipulates whether or not there's any vegetation on that land that needs to be particularly protected, more so than ordinary vegetation. And there's two particular overlays that you should always look out for on a job. They're the vegetation protection overlay and the environmental significance overlay. There's also things like the bushfire management overlay and a number of other overlays on land which could also potentially apply. So obviously before I advise my clients to get started on a job, be that routine maintenance or a new development project, we map the entire area from a planning perspective to see what those legal controls are looking like. In addition to the environmental side of the tree protection under the planning framework, we also have biodiversity conservation laws. I'm not going to talk to those in any detail this morning, but just to flag that they exist not only at state level, they also exist at federal level. So it could well be, depending on the type of work you're doing, particularly if you're building, for example, a new pipeline, and you're doing clearing associated with that, that you could also be triggering the Environment Protection Biodiversity Conservation Act at the Commonwealth level. So there's 2 tiers of regulation for that. I think more relevantly, though, for many of you, particularly in the urban environment, one of the main other controls that sort of goes hand in hand with the planning laws are local laws, or bylaws as they're often called, which are laws that are made by the local council that identify specific trees in the municipality which are to be protected. And that forms an additional layer of control, and you may also need to get consent from the local council in order to work upon those trees. If you're doing works in the road reserve, as utilities commonly are, at least in the towns and cities, the Road Management Act is a further level of regulation that applies, and that has some quite confusing requirements with regard to giving notice and coordinating with the local council or Vic Roads, depending on who's the road owner. And then you come into the utility-specific regulation, and each type of utility has its own legislation which empowers the utility companies to run the network and develop their network. So we have a body of law for the electricity industry, we have a body of law for the water authorities, and we have a body of law for gas pipelines, be they distribution and transmission pipelines. Some of the first things that I think always worth thinking about on every job, ascertaining exactly what it is you're going to be doing if you're involving yourself with tree clearing, pruning, works to root protection, anything of this nature. Are you doing it in an operational clearing perspective? Do you already have an existing utility asset that you're working upon, or are you doing new development works? Because how you answer those questions determines what types of consents and permits you may need. Are you dealing with native or non-native vegetation, or both? And the law, again, has differences in how you would approach that. Where you're doing the works has a big impact on the answers to some of these questions and what types of considerations come into play. Road reserves, as I've just said, are subject to the Road Management Act, and you'll need to be liaising with council or Vic Roads. Private land has its own requirements with regard to consent, and the specific requirements when you're doing works on Crown land, coastal land, parks and reserves, national parks and things like that. For the purposes of today's high-level discussion, we can assume that most of my comments will be around what happens in urban areas, but some things to think about there. And then obviously, if you've got your utilities, which are the utilities that you're working with? You know, are you in shared trenches, or are you just dealing with a single utility asset? Some of the things that you need to consider every time, as I said, for you, given that the Planning and Environment Act and the planning schemes are so important in this area, one of the things that I'd always recommend is that you go onto the Planning Schemes online website, which is a free government website, get yourself a planning property report for the area that you're going to be working in, and check what overlays exist, check what the specific requirements are with regard to tree works on trees. And then you can turn to the specific requirements of Clause 5217, which is the main statewide provision in the planning schemes that covers if you're doing work involving native vegetation. You may require a permit, and in fact that's the default position, is that you would require a permit if you're going to be doing anything involving native vegetation. But there are some exemptions, and I'm going to talk to those in a minute, because there's some common exemptions which are available for works involving lopping, removal or destruction of native trees. Obviously, local laws change depending on the municipality that you're in, so just because you work in one region normally and you then start work in a different region, it's always necessary to check the local laws, do a search, satisfy yourself that there's no consent requirements or specific requirements that the local council in the area you're working may have. One of the other things to do, and it's a further sort of requirement, I guess, is to think about whether or not the tree is additionally protected by being covered in the Victorian Heritage Register or the Aboriginal Heritage Register by virtue of its aesthetic qualities or its historic or cultural significance. So notwithstanding that it may not be a species that's not hugely important environmentally, it may yet still be legally protected under heritage laws as well. One of the questions that I think has been raised previously in this forum, and I've had some discussions with some of your colleagues previously, is in relation to, well, what happens if you identify wildlife actually present in the trees at the relevant time when you're doing the work. So that seems to be something that can trick people and catch people up. I'm not going to talk about it extensively today, but just to note that there is a regime in relation to the Wildlife Act that has criminal offences for harming or taking wildlife. So you need to be very aware of what's living in the trees before you start doing work to them. I mean, it's kind of self-evident that many of you would do that, but you certainly need to be aware of that because it's a separate and additional requirement. And just because you are able to get a permit under planning law doesn't mean that you necessarily wouldn't get into trouble if you hadn't also sought an appropriate consent under the Wildlife Act. And then, of course, you may need to get consent from a private landowner if you're doing work on an easement or not on an easement around somebody's home. And similarly on Crown land, there can be various forms of property law notice rights that are just ordinary course of business where you're going to be going into somebody's land, be that public land, be that private land, and you need to tell them about it in advance, and in some cases you need to get their permission to do it. So Clause 5217 of the planning scheme, as I said, it's a statewide provision, and it requires the default position that you have to get a planning permit from the local council in order to do clearing of native vegetation. But there are some common exemptions to this, and some of the common exemptions I've summarised here. You can go to the scheme, it's available online for free. Some of them are relevant when you're thinking about works that you might be doing around utilities. So one of the key ones that I said at the start was, are you doing operational works, operational clearing? Is there already an asset around which you're doing some pruning, or is it a new asset that's going in? If it's an existing asset and you have cleared previously around that and you're clearing regrowth, there is a very clear exemption in Clause 5217 that allows you to do that, provided that the regrowth clearing... Hi.
Yeah, sorry. With native vegetation, I've had different councils say different things. Is that native to Victoria or native to Australia?
For the purposes of the local councils, they should really be following Victorian law. But because there is also this federal level Environment Protection Biodiversity Conservation Act, there could also be species that are nationally threatened, which throw up a trigger for you to also seek consent at a federal level. So in practice, you would consider both, but generally, the local council, I would have thought, would be more concerned about local matters. Yeah. Yeah, it's two tiers, and you've got to check both of them, essentially. Hi.
The same planning scheme, native vegetation is something that occurs with Victoria, conditions?
Yeah, I think that's right. I think it would be difficult for the Victorian state government to legislate for nationally protected species because that's the domain of the Commonwealth government. So I think the planning scheme, yeah.
Is it correct it only applies to land 4,000 square metres in greater?
That's the I think it's
2,000, isn't it?
4,000.
Sorry, what applies? The planning scheme or?
Clause 5217, as far as I know, applies only to land 4,000 square metres or greater.
I am not aware of that.
So I'll jump in there. So when 5217 or the Victorian planning scheme refers to native vegetation, it's defined in the scheme as being vegetation that's native to Victoria. So
Yeah.
you answer that question, and when we're looking at more widely, we may be talking about Australian native vegetation, be it plants or animals and things. Now, it's not that it doesn't apply to land under 4,000 square metres, but there's an exemption. So the 5217 applies to all parts of Victoria, but there's a truckload of exemptions, which means we don't have to worry about in some situations on land under 4,000 square metres, 5217 doesn't apply.
Yeah,
Sorry.
thank you. Yeah, the starting point from my perspective as a lawyer is to assume that it does apply unless an exemption is in place that's very clear for you. So it obviously depends on the nature of the asset that you're going to be working on or near, where it's located, how big the easement you're working in is, what its size is. I wasn't personally aware of there being a maximum size. So, I mean, the starting point when I'm working through these things with my clients is to look at, the default position, which is that a permit is likely to apply, and then work from there. Relevantly, obviously, we've had the situations where you've got regrowth and it's permissible to go in and take out that regrowth. You don't need to be concerned particularly about that, and that's very relevant when you're doing operational works. When you've got, similarly, dead native vegetation, there's exemptions for clearing out that, particularly around utilities. There's exemptions for road safety as well, to make sure that you don't need to be worrying particularly about clearing out native vegetation, lopping that and pruning and so on, if there's a legitimate public safety basis for that, for road safety. Right, so what I wanted to do really now was just walk you through, I suppose, some of my legal perspectives advising utility companies in relation to, I can see there's a gentleman's hand at the back of the room. I'll take that question.
I've just got one more question with regard to exemptions. The 1030 or 1050 rule, I was wondering if that was an exemption under 217. The December 2017 amendment, has that addressed that through reference to consequential loss?
Yeah, I think it has addressed it. So one of the things for those of you in the room who aren't familiar with this regime particularly, and many of you I assume would have some day-to-day knowledge of it, is that in December 2017 there was some fairly major reform of the planning schemes in Victoria to accommodate a new Victorian government policy in relation to clearing and offsetting. And so there were some consequential changes to the exemption provisions and to clause 5217, as well as other clauses in the planning schemes. I actually, because I don't have a copy of it in front of me, I can't say whether that was amended or taken forward, but you're certainly correct to note that. And for those of you who haven't gone back and looked at the planning scheme in the last 6 months, please do so, because it did change in December and there were some fairly big changes that came out of that. All right, so I'm going to talk now very briefly about some of my, I suppose, observations working in and around gas, utility, infrastructure, particularly pipelines, water, pipelines, and also a bit about electricity. And then I'm happy to take some questions at the end about anything that discussion throws up. So as I said, I've spent a reasonable amount of time in recent years advising in relation to pipelines and underground infrastructure. One of the things that's quite important, I think, to note at the outset is that there's essentially two types of gas pipelines. One is the transmission pipelines, which are the high pressure, really big, long distance pipelines that carry compressed gas interstate across the country. And they're the transmission pipelines. They carry it from the storage, from the manufacturing facilities, from the gas fields, and they carry it across the state. There's also then what we call distribution pipelines, and the law places a difference on this interpretation, and they tend to be the lower pressure, smaller network of distribution pipelines which carry our gas essentially into our towns and cities, right up until our front doors. And that distinction, I suppose, between transmission and distribution is reflected in the Planning and Environment Act and the planning schemes. And it affects whether or not gas infrastructure is characterised as a minor utility installation, which the smaller pipes are, or whether it's a utility installation, which the larger of the pipes are. And there's slightly subtly different rules depending on which pipelines you're talking about. So the main thing that I wanted to flag in terms of legal requirements or legal approvals is the Gas Industry Act and Section 148 of that Act. That's the main section of the legislation which gives those gas companies the power to enter onto land on either side of pipes or equipment, so essentially in that what we'll call an easement, for want of a better word, although they may not always be formal easements, to remove the tree or any part of the tree or any obstruction, which in the opinion of the gas company or gas transmission company, so it applies to both distribution and transmission, it's necessary to fell or remove. What we can see from that is that's a pretty broad power, and it puts a pretty broad power in the hands of the gas company. They have to decide whether they feel it's necessary to take out the tree, and they can do it not necessarily on the basis that there is an obstruction. So there can be any number of potential bases on which they may consider it necessary. So in my mind, I think gas companies have quite a good run of it in terms of their powers. They seem quite broad. There's certainly a very clear legal basis there for being able to do that, subject to them giving that 7 days notice to the occupier. In the case of transmission companies, they may also be separately licensed under the Pipelines Act. And they may well have licence requirements in relation to clearing. It's very common to see that in relation to, I work for utility corporations across Australia, and licence conditions very often include conditions that have been approved in relation to the clearing of regrowth vegetation and maintenance of easements and things like that. They're also required to have an environment management plan, and that EMP may well stipulate requirements that have been approved in relation to clearing. And they're often subject to easement rights. At the point the pipeline was granted, particularly for the larger pipelines, of course, they were often granted government concessions and formal easements, which allow them to own the land and occupy it, essentially, for the purpose of running the asset in perpetuity. So there's often it's not inconsistent to see easements, for example, which contain provisions in relation to the management of native vegetation. In addition to that, legal requirements on the gas side coming out of the main gas legislation, as I said, you've also got to consider the planning scheme and what it says. And there is a specific requirement in the planning scheme for a permit, but there's an exemption, of course. And that exemption allows you to clear native vegetation for utilities, to maintain the safe and efficient function of a minor utility, so that would apply certainly in the case of the smaller distribution pipes, or buy on behalf of a utility service provider in the case of construction. So relevantly, what this says is that the larger the pipes that would be classed as utility, not minor utility, they do then re-trigger this need to consider whether or not a permit is required for the clearing, subject to any of the other exemptions applying. Okay, I'm now going to turn briefly to the Water Act and the position v water authorities. I think their position is possibly clearer, but they possibly have less powers than a gas company. And I think that's probably very relevant for many of you, because my understanding is that water pipes in particular can be quite a big source of root management, and the reason why you may get instructed in relation to a job is to look after trees that have come into contact with water infrastructure. So one of the main things about the Water Act is that it only really applies in circumstances where there is actual obstruction or damage to the water authority's pipes. It's very clear about what happens in that situation when there's tree roots that have got inside a pipe and they're actively obstructing it, and it's clear about what happens if the trees are outside the pipe but they have damaged the pipe in some way. And what happens in that situation is that the water authority has the power to remove the tree, and it does that if it reasonably decides that there's a basis for doing that because it's obstructed or because the tree has damaged the pipe. And the way that it does that is that it serves a written notice on the occupier of the land that the occupier at its cost has to remove the tree. The landowner can object. The water authority has to take into account that objection. It has to make a decision about whether or not it's going to uphold the objection or whether it's going to full steam ahead and require you to take out the tree. There's even a right of appeal to VCAT if you're not happy that the tree should be removed. And then if VCAT's made its decision, or if the matter hasn't proceeded to VCAT and the owner actually refuses to take out the tree, then essentially within 7 days of notice, within 21 days of notice, the water authority can recover the tree itself, and then it can come after you for the costs of the tree. I say you, the landowner. It can come after the landowner for the costs. What I think about this process, I guess, is that it requires a few things. It requires a bit of evidence here that there is actually an obstruction of tree roots inside the pipe, and it also requires some form of evidence on which the authority would have to reasonably put their claim that the tree is causing damage to the pipes. And so I think certainly faced with this situation, be you a local council or a private landowner receiving one of these sorts of notices, it's certainly worth checking what the evidentiary basis is for that notice being issued, because it's important to understand, why they say the whole tree should come out as opposed to some other measure. One of the things that is apparent is that if they do cause any damage more broadly to assets, then water authorities are liable to compensate in relation to that damage. And particularly that's the case if the tree was there first. So if the tree came before the water mains were there, then you're entitled to compensation for the loss of that tree that's had to be removed. What I wanted to contrast this to is the more common situation potentially where it's not necessarily alleged that there is an actual obstruction or that there is actual damage to the pipe, but where a water authority just wants to get into its infrastructure and there may be trees around it. And one of the common questions that I'm asked is in relation to, well, what measures does the water authority have to take to protect the tree? What preventative or mitigation measures do they have to take? Do they have to provide water treatments, for example, to allow the roots to be identified in situ, to allow that sort of protective measures. And the kind of sad thing is that there is no process for that under the Water Act, and so there's no formal requirement for the Water Authority to pay. On the upside, there's no formal requirement that they don't have to pay or that nobody should have to pay. And so what I have formed the view really is that in the ordinary course of works, if works have to be done around a tree root system, then really it needs to be recognised that trees, particularly street trees, are an asset, and an asset like any other that requires some form of protection. And so my view is that cost apportionment should really fall with the Water Authority for that sort of work, because there's no clear indication at law that they would have to, that anybody else should have to pay for that. And one of the reasons for forming that view is that the law does try to provide, as best it can, that the water authorities are really supposed to undertake their obligations with as little harm as possible to the environment, and they are supposed to leave the condition of the land in as good a position as they found it in when they did the works. And of course, if they do actually cause loss of or damage to trees in the course of their works, even if unintentional, then they are bound to pay compensation. Okay, so electricity, the final utility that we'll be covering this morning, and I should preface this by saying that I've spent a lot of my time dealing with underground pipes. I've spent a lot less time dealing with overhead cables. But I wanted to cover it for the sake of completeness this morning, because it really flags up that fact that we have yet again a further set of legal requirements, and each time you do need to go to the correct set of laws that govern, in this case, the electricity industry. So the Planning and Environment Act specifically defines power lines less than a certain voltage as being minor utilities. What we take from that is that power lines that have a higher voltage than that, particularly the large transmission power lines, are utilities, not minor utilities, and that then has a bearing on exemptions for clearing. We have electricity safety legislation, and this is really the main legislation that governs clearing in this space around power lines. And relevantly, rather than having a bit of a regulatory vacuum as we do with water and gas, and a bit of a reliance on codes of practice, we actually have some regulations of 2010 which provide the legal basis for clearing around power lines. There is a code of practice, of course. There's a code of practice in each of these areas. But certainly the regulations are the main source of the law in this regard. And what it essentially does, unsurprisingly following the bushfires, is that there is a much, much clearer mandate to clear vegetation than in the other two regimes. So from a purely safety basis, there's a mandatory obligation to go out there and keep your trees pruned and well managed so that they can't interfere with power lines, whereas the safety case doesn't quite exist in the same way for water and gas utilities. One of the things that electricity operators are required to have is a management plan which identifies areas with native trees, and those listed in the planning scheme of ecological, historical and aesthetic significance, or cultural or environmental significance. That's a hugely broad definition as defined in the regulations, and so what you should find if you're ever involved in doing work in and around a electrical utility for power line pruning, for example, is that management plan should be pretty detailed as to the existence of trees that you're going to be working on. I'm conscious of time. I'm conscious that I'm pretty much all that's keeping you between you and your morning tea. I'll happily wrap it up there and take questions, or feel free to chat to me one-on-one if you have any questions or concerns. But the one takeaway is it's complex. Get your compliance documents in order. Get your cheat sheet to take out to sites with you. Work with your principal contractor if you're unsure about what the legal requirements are.
Okay, we have probably a couple of quick answers.
Sure.
Make your questions even quicker, and we'll get through a couple. Andrew? Oh, sorry, Cameron.
Okay.
Yeah, I've heard different sides. Does the Flora and Fauna Guarantee Act cover private land?
No.
Thank you.
Next question. That was easy.
Sorry, just in terms of the complexity of layers, in terms of what overlays.
Yeah.
In terms from a liability perspective, would it be smart to sort of not specify to people whether they need permits or not unless you're 100% sure that you've sourced every available option, or leave it to the planners to give that answer? If a client's
Yeah.
need a permit and you go and check the plan overlays, if it says no, surely there might be something else that you haven't got access to.
Yeah, that's right. So, particularly with regard to planning permits, I think you need to be getting from your client a sort of sign-off that they have actually had planning advice from their professional planner or their planning lawyer as required, that they have actually bottomed that issue out.
Liability could run down to you.
Yeah, because if you fail to ask for that information to your satisfaction, then you're potentially going to be in the position of unwittingly kind of committing a criminal offence potentially. And so it's important that they understand that they've got to give that information to you. What I would say, in being a lawyer, belt and braces approach, is that even if they do give that information to you and they try and fob you off and say, yeah, mate, we've checked it, there's no planning permit required, probably always helpful from a personal liability perspective to have a cheeky squiz at it yourself.
Well, it's sort of the flip side,
Yeah,
actually.
but that's really more for you. It's really more for you in terms of, understanding, your comfort level for doing those sorts of works. One of the things I haven't spoken about this morning is case law in relation to this area and how likely it is that people do actually get prosecuted or into trouble. All I can say really in 2 minutes is it does happen. You certainly should assume that this is not something that I'm sort of making up to scare you. It certainly does happen. And for utilities in particular, you're doing these works in the public domain. You're doing them in plain view of the community. And we have in Victoria a very, very articulate and aware community, and it only takes one complaint from an interested member of the public to bring things down. So do be aware of that. Unlike works on other forms of land where you might not be in plain view, you certainly are in utilities, and that's one of the big sort of reputational risk management points for many of you, I think, for your own businesses and for your principals. Thank you. Thanks very much for your listening this morning.
Thank you.